The session that we have today is hosted by ORF and NIXI. It's the future of data, territory, and jurisdiction. For some of you who had come for the sci-fi conference last October, you know that our inaugural session also dealt with the same topic. It's quite a vast topic, and that's why we're taking up this issue again. ORF and NIXI are working together to look at the issue of data jurisdiction and national sovereignty and the various approaches that can be taken to resolve these issues. So, in order to do that, we've assembled a number of experts who can give us their views on the subject. I'll read out very brief introductions. We have with us Dr. Govind, who is the CEO of the National Internet Exchange of India, and until recently, he served as Senior Director, heading the e-infrastructure and internet governance areas in the Department of Electronics and Information Technology, the Government of India. We also have Bertrand de la Chapelle, who is the director of the Internet and Jurisdiction Project. He served as the director on the ICANN board from 2010 to 13, and I'm sure most of you are aware that ICANN just finished its meeting in Singapore, and I'm sure you've all been reading up about what happened. We have with us also Pavan Duggal, who's an advocate at the Supreme Court of India and an authority on cyber law and e-commerce law. He's a consultant to international organizations, including the UN, the Council of Europe, and the Asian Development Bank. And instead of Sami Saran, who is down with the flu, we have roped in Dr. Ranjana Kaul, who is a partner at Dua Associates, a leading law firm in India. She specializes in the area of aviation and aerospace law and regulations. And her practice also deals with corporate law, joint ventures, and M&A. All right, so ma'am, I'm going to hand over the floor to you.
Thank you, Bertrand, for being patient. And here we are, setting the ball rolling. As Mahima has just told you that I deal with an area which is somewhat higher than cyberspace. But having said that, the question of jurisdiction and linked to sovereignty and linked therefore to responsibility and linked therefore to liability are issues that are plaguing and are really confusing the broth as far as cyberspace is concerned. We are at the present point in time, as you all know better than me, dealing within our own national jurisdictions. May I request Dr. Govind to give us a roundup of exactly how and where India stands on the subject.
Good evening, ladies and gentlemen. It's a call, Mr. Bertrand, Pavan Duggal. So when this topic came, we and Mahima talked about it about a month back, when the Bertrand would be coming to India after the recent ICANN meeting. So I was wondering what kind of thing, because Bertrand is a large experience on this space in the internet and jurisdiction area. And this is an area where, it bothers everyone. Even in the recent ICANN, I have seen that the issue of the transition space in the IANA, the names and numbers issue also, the main issue was the jurisdictional issues, where, where to deal with these, any dispute comes between the countries for when the domain name is allocated or when the numbers are allocated. So we have made, I was member in the CRISP team of the numbers team. So we gave a framework, we gave a proposal, but this is nothing to do with the jurisdiction, because we said jurisdiction would be an overall arcing issue which will be anyway be coming up in the ICANN parlance, and then the accountability would be there. So this organization with the ORF and NIXI, we would like to see that how this issue of jurisdiction and internet, because internet is an all-pervading medium. When idea of jurisdiction is connected almost to the concept of territoriality, both in legal systems and in the minds of a layman. The fact that internet breaks down the concept of territoriality is undisputed. As more and more commercially activity and personal interaction moves online, it is becoming impossible to leave unresolved the question of jurisdiction over the online space. There is no doubt that governments also have a legitimate interest in regulating criminal activities online, which has an impact within the territorial boundaries. So the internet is today the borderless medium, but the national laws are there from the time immemorial, because every country has its own jurisdictional thing. AMLAT, mutual legal assistance treaties, and similar instruments are helpful under certain circumstances, but they are not efficient. As time is of the essence, in such cases, it is necessary to look for solutions which would allow more fluid and efficient collaboration between the governments. So when the more and more issues because internet is expanding in the e-commerce side, the governance side, the communication, and the entertainment, all sorts of things are happening through the internet medium today, which were not happening about few decades back. But what is happening today, the issue of how to deal with if certain kinds of crimes happen, certain types of content, certain types of things happens, which is who to deal with, how to deal with it. That is the issue which we need to grapple here with. The other issue is, which is very unique to the internet and jurisdiction, is the differences in the legal as well as cultural standards across the world. Even if the legal, we say, it varies from country to country, and the cultural sensitivities are varying from country to country, because whether it is Brazil or whether it is India, whether it is Saudi Arabia, or whether it is France or US, the cultural aspects are becoming more and more important in internet today than any other aspect compared to the communications and the emails and the other thing which we are already doing. So how to deal with the cultural sensitivity with the time, and how the legal aspects will deal with it. Because the norms are different in each country. It is changing from time to time with the maturity of the public, maturity of the people who are using the internet. The same norms are not remain the same. It is changing with time. Today it may be a derogatory remark, today may be not a derogatory remark tomorrow. How to deal with those kind of situations? Then the governments have become more concerned with this issue, and in the light of Snowden revelations, how the data has to be protected. Because data is becoming the more and more important from the point of view of his free movement across the borders, and whether it is the knowing with that the Brazil has made out a local traffic to be moved within the country in their jurisdiction, and then the data localization of servers that has came up as an outcome of those kind of Snowden revelation, that many countries start trying to do those kind of, fine-tuning of their network in their own country. But as you know, the internet is a network of networks. It is not that something, it's a global network. It was evolved from the defense DARPA project in the US in 1969-70 time framework. And the transmission control protocol and the IP protocol, which are the building blocks of the internet today, it doesn't make any, they are irrelevant or technology agnostic for the things which are moving the packets within the internet. So they are not aware which packet is moving from which place to which place. So it is the content, it is the substance of the whole thing which is making more and more effect on the internet's parlance. But then how we must analyze whether cyberspace will bend to be idea of territoriality or vice versa, and whether there is an optimal solution which allows for the free and unrestricted flow of information and without balkanizing the internet. So whether with the data localization issues, the data protection issues, the privacy issues, and the freedom of expression issues, whether these things are going to make any dent in the internet, whether the legal issues are going to, how to deal with these issues, even the net neutrality, this is the internet governance issue today. How to deal with those kind of things in the internet space, though the cyber security, I will say it is the 10% of the total internet space which covers the internet governance issues, but it is becoming more and more important from the socio-cultural point of view in the society. Because because we are doing 90% of the internet, the networks, the e-commerce and other areas, but how to deal with the security aspect, the privacy aspect, the data security aspects. So there are varied concepts, varied opinions across the world about these issues, but how to deal with these in the various countries, that's an issue which is bothering people across the world. And there are, Budapest Convention is there, OECD norms are there, and there are many issues, many frameworks which people are working on this, but no global framework is yet on place, because every country has its own way of looking at the issues and the problems and the way to go forward about it. Courts around the world have evolved a number of stopgap measures to adjudicate cases involving online activity spread across jurisdictions. The effects test, in particular, tries to break away from a very rigid or textual legal analysis and tries to ascertain if the online activity was aimed at a particular jurisdiction. So how the cause and effect in the legal term, which I believe more of the legal fraternity here would be able to say more about it. So, but how to deal with this, the common man's angle, how the jurisdictional issues are going to impinge the global internet, how fast we can tackle these jurisdictional issues in the problem-solving framework. However, deciding the issue of where jurisdiction lies is only one part of the puzzle. Countries have very little extraterritorial enforcement powers and therefore has to depend on the assistance of other governments. Here I will say the internet is a collaborative medium. How there is a need to consultative, collaborative, consensual means to tackle the issues of the internet governance as well as the cyber security and the jurisdictional issues. Unless we cooperate, because internet is a cross-border phenomena, if one country documents sharing with the other country, it solves certain problem, then that has to be done. But for that, there is a need to a framework. Who should ask the document from one country to another? Who is the authority, authentication, the content of that framework, what format it has to be submitted. So all these issues are coming when we look towards the internet and jurisdictional issues. US and other major European countries are more successful than others in the developing countries on the issue of solving these internet and jurisdictional matters. However, their laws in the countries like India, in the Asia Pacific region, we are most of the time on the receiving side of the whole thing because we get often the data which we are required for this problem solving is not received at the time, in the timely manner. The CERT and all, they are already grappling with the issue how fast we can get these problems in the data space. So Bertrand here sitting and he is working on this project last 2.5 years. And I'm interacting with Bertrand for the last, I think, 7 years as an ICANN GAC member first and then the director in the board. And Bertrand has very, calmly brought out this issue and from his vast experience in the ICANN space where the numbers, names, and the security and all issues are dealt with in the domain name space. But I think this whole gathering today would benefit from his presence here and the what way he looks at the whole process of jurisdictional framework to be developed for the advancement of the legal issues in the internet space. And, and then I think the developing solutions for in this matter would be in another aspect, how for the acceptability of those framework in the larger framework of the internet and how the various countries are going to deal with it, what will be the mechanism of acceptance of these things and how the internet, there are many issues which would be coming up thereafter, whether how to deal with certain crime and the e-commerce content takedown issues and all those things. But I feel that the present gathering, we will be able to discuss these issues in an amicable way. Thank you very much.
Thank you, Dr. Govind. I see a great parallel actually with outer space, where every country has developed its own capabilities to be self-sufficient, and yet realizes now that the only way to ensure security is cooperation. Whatever be the national objectives, well, that they are, and those do not get diminished, but cooperation is the way forward. And may I therefore request Mr. Chapelle to kindly tell us what he's been working at and how, through this model, we could help.
Thank you very much. It's a great pleasure being here. As Dr. Govind has kindly mentioned, we've been working on this activity for about 2.5 years now. The project that's called Internet and Jurisdiction, you have on your table a progress report that we recently produced on what we call the phase 2. We had a first year in 2012 that basically framed the problem. And In 2013 and 2014, we facilitated, Paul Fellinger was in the back of the room, is working with me on this. We have basically acted as a neutral facilitator for allowing the different categories of stakeholders to discuss this issue. As you mentioned, the issue of jurisdiction is an extremely broad topic. But the starting point was, given the cross-border nature of the internet, there is a natural tension with an international system that is based on geographically defined jurisdictions. And for those of you who are lawyers, of course, the architecture of the international system is based not only on the geographic jurisdiction, but on the separation of sovereignties. It's basically a system that starts from the assumption that countries and governments are the masters of their own territory and their law applies to their territory, but they shouldn't impinge on somebody else's territory. And so this separation of sovereignty is really difficult to maintain and to use as a starting point for solving issues that are fundamentally, increasingly dealing with cross-border interactions. And so we're a little bit in a conundrum whereby if we reinforce and we reimpose a very strict territorial system, we risk losing a portion of the benefits that the internet and its transborder nature has provided. But if, on the other hand, we still stick to one of the early assumptions, which was basically the location of the operators is determining the applicable law, we end up with a real imbalance, whereas operators who are based in one country basically apply the law of that country at an international level. This was a starting point, how to handle this tension between the cross-border nature and the internet and the national jurisdiction and the patchwork of national jurisdiction. To make a long story short, because the different actors were seeing that there is no international framework, there are intergovernmental discussions. There are guidelines among companies. There are civil society statements and advocacy. But there is no space, actually, where all these different actors can come together and try to address the common problem. And one of the challenges in that regard is if every single actor is using basically its own tools, the likelihood that each of their decisions is not coherent with the decisions of others is very high. And the more incompatible they are, the harder the problem becomes afterwards, because as you know, it's much harder to harmonize laws after they've been adopted and diversion rather than trying to foster some kind of convergence. So we organized a series of meetings, what we call the multi-stakeholder dialogue process, that has worked particularly in 2013 and 14. In 2013, we organized 4 key regional meetings, one in Brazil, one in Europe, in Paris, one in New Delhi, and one in Washington. And in 2014, we did the same with one key meeting in Paris and a lot of interaction and discussions with the different actors during the course of the year. And the goal of all this is to develop what is labeled as a transnational due process framework for handling the increasing number of direct requests that come from law enforcement or public authorities in one country to platforms and operators on the internet that are located in another country. One of the distinctions between what probably Pavan is going to talk about is if you look at the cybercrime space, there's a huge effort to do harmonization on substance, because the goal is to have dual incrimination, that something that is recognized as a cybercrime here is also recognized as a cybercrime there. The Budapest Convention is one angle, you get mutual legal assistance treaties, et cetera, et cetera. But there is another domain, which is the one that not us as facilitators, but the participant in this process that now are more than 80 different entities, government, civil society, private sector, international organizations, and DNS operators. But that those actors have highlighted is issues that are related, for instance, to speech. And in user-generated content and all those platforms that deal with content, the challenge is that in many cases, things are legal in one country and not legal in another one. The perfect example, I come from France, Paul comes from Germany. In both those countries, issues relating to hate speech and particularly anti-Semitic statements, because of history, are criminal. Surprise, surprise. In the US, it's protected speech. And this has created huge tensions with the major platforms, including Twitter in France, and I'm sure it's the same in India when there are tensions that may emerge at the local level because somebody has posted in another country, in the region or elsewhere, things that trigger tensions between the different communities. And so the focus is to develop this transborder due process framework for requests, for domain seizures, content takedown, and access to user data. And the general idea is those requests are growing today. They exist. There is already an interaction between a lot of countries and platforms. It can be large platforms, small platforms. It can be large countries and small countries. A certain number of interactions are happening on a case-by-case basis or as informal trust networks. But in a certain number of situations, there is no real clarity on the procedures, no real transparency or due process. And this is actually harming the different actors because the lack of predictability is a major issue. And so what has emerged out of those 2.5 years of discussion, which once again involved more than 50 meetings in which we have either organized a meeting or participated in more than 19 countries, what has emerged is a draft architecture for this regime, this multi-stakeholder regime. And if you look at the document that you have, there is one drawing that you can see here, which is basically describing the two pillars of this regime. And without making too much detail right now, because we can discuss that further, the general idea of those two pillars is those requests need to be formulated and transmitted, and they need to be handled by the receiving entity, the platform or the DNS operator. And so the first pillar is basically a request submission system, which is, we jokingly qualify it as the plumbing, like it's basically how these things are being prepared and transmitted. And the second pillar is about request handling procedures. So request submission system rapidly is based on a common and a standardized request format that is using a series of markup tags, a little bit like HTML tags, to describe what the content is and the structure of those requests. And attached to this format is the idea of having databases that are mutualized to ensure statistics for transparency reports and a legal reference database that basically keeps track of what is the applicable law in the different countries. Without elaborating, the development of the database that tracks the applicable law is a huge endeavor in each company. The large ones can do it, but if you ask them, it can be Google, it can be Facebook or Twitter, it's a huge effort. And this is completely out of range for the smaller companies. Most of all, it's duplicative because each one is doing the same. So the idea of having a database that keeps track of this is actually useful for all the different actors and spread the best practices. There's an element regarding authentication of the sender. Today, platforms receive requests that may come from the law enforcement agency of Kenya, but actually it's a Yahoo Mail account. And it is difficult to be sure that it is the intended actor. So there's an element of authentication. And we organized last week at the Interpol offices in Singapore a meeting with law enforcement to see how they can play a role in authenticating the emission of those requests. Finally, the second pillar is related to procedural aspects and procedural guarantees. And this has to do with procedural predictability, like trying to develop and document the best practices that the major platforms are using today, and they have not necessarily written them down or shared them, so that it serves as guidelines also for smaller platforms on how to handle the requests that they're receiving. Because let's be honest, it may be a little bit provocative, when you're a very, very small platform, you have a very small legal team, if at all. You receive requests, and the temptation is to do one of two things. Either you just ignore them, you don't respond, you stonewall, or you basically accept any request that comes because it's the fastest thing to do. And both attitudes are not good for any actor. It's not good for the system, and it's excessive on both hands, and it doesn't provide a stability mechanism. So procedural predictability, defining common procedures and criteria is extremely useful for everyone. And there's another dimension, which is the dispute management mechanisms. And I insist on the term, it's not dispute resolution mechanism, because there's no way to arbitrate, basically, between a country and a platform or a DNS operator. But it is establishing dialogue mechanisms, appeal systems that facilitate the resolution of tensions and diminishing the tension between the different actors. That's where we are. We have facilitated this network. You will see in the documents that have been distributed that there's also an observatory that has 34 experts in different institutions around the world, including in India and in Brazil. And this observatory is producing a monthly newsletter called Retrospect that lists 20 cases crowdsourced to document the environment and produce an evidence-based process. This is intended to be developed further during this year to the aim of an actual implementation in 2016. I want to insist on two quick points as a conclusion. One, we have voluntarily, from the onset, engaged very closely with countries that are not in the traditional transatlantic environments. It's not a European, American type of discussion. It involves other actors, and India and Brazil have been two countries that we've really wanted to engage from the onset, and we're very happy to see that it is a discussion that is going on. The second element that is very important is that on speech-related issues, contrary to what we may discuss on cybercrime and so on, there will not be, and there should not be, harmonization on substance. The criteria in each country are going to remain the same, specific to those countries, because in many cases it's specific to the identity of the country. So what needs to be done, and what we focus upon, is procedural interoperability, establishing criteria of due process so that there is a capacity that does not exist today to enable the interaction between very heterogeneous actors that are the private sector, the civil society actors, the governments of various sorts within the government, on issues that are of a common interest. And the thing we're most proud of, I would say, is that we believe we have managed, through the facilitation of this process, to provide a neutral space and also to transform the problem that the different actors had with one another into a problem that they have in common and that they want to solve in common. And we see a convergence of interest around this notion of transnational due process that I think is very encouraging. We're not completely done yet, far from it, because you can imagine. But it's a very good opportunity to make a sort of update on where we are, and I hope that the report report is describing accurately what we've done.
Thank you, Bertrand. And I have to say that you have undertaken a humongous task, which so many, well, okay, it will finally, when it's successful, we'll say, oh, we always do that. It was just so easy to get done. But I know that any kind of cooperation to bring people in the first place to a common table, just simply to dialogue, is the most difficult part of it. And I'm also happy to note that there is an element, a building block, important one, of capacity building and training, which would of course have to be ongoing. May I now ask Mr. Duggal, who of course everybody sees on television quite so often, criminality, firstly to give us a lay of the land, so to speak, of what the developments have been, and also whether this criminality is distinguished between a crime against the state and a crime against an individual or entity, whether it's a person or a corporation, and distinguish that, if you will, with civil wrong, where there is unintended consequence or harm that is caused, and whether these kinds of liability issues are something that you could tell us about.
Thank you, Ms. Chairperson. Distinguished panelists, friends. Yesterday, Kaspersky Labs tells us that $1 billion stolen from 100 banks by hackers. Let's take that as a starting point for discussion. We don't know the location of these 100 hackers. We also don't know the location where the money of this $1 billion has gone. A lot of this money has trickled down to the deep web and the dark web, and the traces are virtually not enough for law enforcement to go after them. So in a scenario like this, the bigger issue that emerges is, what is the landscape? As a lawyer, I'm confused. Where are we standing? Primarily because we are still talking about safe world, safe jurisprudential concepts. But the concept of safe worlds has to give way to the digital dark ages, which Vincent Cerf is now beginning to talk more and more. So in this digital dark ages that we're talking, where there's darkness all around, where the Snowden revelations tell us that it's not just non-state, but even state actors who have an integral role to play in activities which could go in the gray area. The bigger issue now is, how do we determine jurisdiction? Where does jurisdiction start? Where does it sustain? And where does it end? At a time when internet had made geography history, the inventors of the internet, Bob Kahn, Vint Cerf, had actually no clue that jurisdiction could be a huge problem. In the last, more than 40 odd years, we've not been able to find the magical solution of how to deal with jurisdiction. The World Wide Web, while it actually was ushered in by Sir Tim Berners-Lee and actually went ahead and increased convenience of access, but further contributed to, shall I say, complicating the entire issue of jurisdiction. So in a scenario like this, let's take this scenario. The FBI pulls down the Silk Road. Silk Road 2.1 was pulled down 2012. Silk Road 2.0 was pulled down last year. The fact still remains that while proceedings are still on, we haven't moved anything further. Of course, challenges of jurisdiction have been taken in those proceedings as well. But broadly speaking, when one looks at the landscape of cybercrime, one can classify the landscape into three broad categories. World over, cybercrime can be classified as cybercrimes against persons, against property, and against nations. Now, in the event that you're dealing with cybercrimes against persons, it's simpler. It used to be simpler. It's got more complicated. It gets more complicated in countries like India, where the mobile web is unique. 61% of all Indian online users are only accessing internet through their mobile devices and nothing else. So in a scenario of the mobile web, where the user is constantly mobile, issue of jurisdiction tends to get a different paradigm and a different, shall I say, color of the canvas altogether. Now, one can look at the territorial school of thought, versus the international school of thought versus the universal school of thought. Now, territorial school of thought is what majority of the nations actually rely upon. The Snowden revelations have made nations even more determined to rely upon territoriality as the basis for assuming jurisdiction. Data localization has only helped them to enhance the cause of territoriality. Why? Because if you're Russia, you've recently passed a law a few weeks back which says that if you're dealing with data of Russians, you will have to ensure that the said data physically resides within the territorial boundaries of Russia. Well, the fact remains that other countries are also beginning to talk about data localization. How relevant is a different ballgame altogether. It's a different debate. We will not look into this because there are cross-cutting references to e-commerce, m-commerce, and how the chances of being in complete digital isolation in a digital ecosystem are itself utilitarian on the one hand or utopian on the other, depending on which school of thought you are dealing with. But let me look at the local school of thought. We are in India. India has adopted a very distinct, unique approach towards dealing with cybercrime in jurisdiction. Normally speaking, the law of the land is that your law will be applicable to your own territorial boundaries. Well, that's where majority of Indian laws are applicable. But way back in 2000, when we enacted this legislation, the Information Technology Act, we made a conscious choice. We agreed that jurisdiction is going to be an issue. Therefore, we inserted cleverly two specific provisions under the Information Technology Act. Section 1, subsection, and Section 1 and 75, subsection 2. Broadly speaking, you would have expected the IT law of the country only to be applicable within India. Ladies and gentlemen, you need to be in for a surprise. Right since 2000, the law says that this law applies to any person of any nationality anywhere in the world. That's what Section 1, subsection 2 says. Now, you will find that absurd. So to give some sanity to this absurd proposition, Section 75(1) comes to the forefront and says, well, you will be made amenable to this law. You may be located anywhere so long as your acts involve or impact a computer system, or computer network physically located in India. That starts to start making a lot of sense. But the fact remains is that in the last 15 years, we've not been able to leave aside successful. We have not even been able to exercise this so-called extraterritorial jurisdiction. Pakistani hackers hacked into CBI's website. A case was registered under the Indian Penal Code and the IT Act. We requested the neighboring country, but the neighboring country had a unique argument. They said that country does not have any hackers, it only has nationalists. So the case came to a just grinding halt. Nothing has happened in the case. So practically speaking, we have not been able to, rightfully so, shall I say, exercise our extraterritorial jurisdiction. But now, while after the Snowden revelations, more and more countries want to have a larger pie of the global digital cake, the fact remains is jurisdiction becomes a very convenient tool to work in that direction. So that's fine, but let's look at this. Korea, a few months back, tested an experiment, and the experiment tested positive. They were able to use a smart refrigerator for the purposes of hacking into computer networks. They also tested a smart oven, sending spam email over networks. Just the practical workings of the Internet of Things. The coming of Internet of Things is going to make the entire debate on Internet jurisdiction even more murkier. So when now the recent debate has recent analysis has come in which says that the smart TV of a particular brand actually is capturing whatever is your conversation in your room, you're beginning to get concerned. Why? Because the conversation is not just only being recorded by your smart TV without your consent, but more significantly sent over networks to locations of computer resources which are outside the territorial boundaries of your respective nations. So in a scenario like this, Internet of Things is going to further escalate the confusion and challenges to Internet jurisdiction at a different ballgame altogether. And as far as the darknet is concerned, I'm crystal clear. Jurisdiction doesn't work. No country has been able to successfully show how it is able to exercise jurisdiction over activities in the darknet because the world community is still not very clear as to where the dark net begins, where does it expand up to, and where does it actually end. So technically speaking, you can flag your flag onto Antarctica and say, well, this land belongs to me. But reality remains that this becomes an extremely contentious exercise as time passes by. Further, the entire issue is that, well, we haven't had any international legal regime to deal with jurisdiction. Well, the Convention on Cybercrime of the Council of Europe was a major step forward, but that was 2001. It also primarily was a European experiment, though it's now gone beyond Europe, and a large number of non-European nations have acceded to it. But a lot of nations in the Asia-Pacific have chosen not to ratify, or not even to go ahead and sign the Budapest Convention, primarily because there are concerns of national sovereignty, there are concerns of jurisdiction, and allied issues per se. So, in the absence of an international regime on jurisdiction, it's each one to your own. So, the framework that Bertrand is now suggesting is definitely a great step in the right direction. However, the question that needs to be examined is that all stakeholders need to be actually agreeing to some common basic denominators before moving forward. But in a constantly shifting targets game, more so after the Snowden revelations, and more so when breaches of cybersecurity have become the de facto norm, getting international acceptance on even basic denominators is going to be a challenge. We saw the process of laying down the rules of the road in the London Conference in Cyberspace 2011. That process went a bit further in the Budapest Convention Conference in Cyberspace, and also in Seoul in 2013. But after Seoul, we just came to a full stop. Nothing happened in 2014. And now, when the Hague Conference happens later this year, it's expected that the so-called ice needs to be broken. So, legally speaking, till such time, countries do not accept the so-called international jurisdiction platform or paradigm, we will begin to keep on seeing scenarios where national countries will only keep on harping upon national jurisdictions. One of the biggest, shall I say, insecurities of state and non-state actors is that they do not want to cede jurisdiction of anything which could prejudicially impact the sovereignty, integrity, or security of a sovereign nation, or even public order, decency, or morality in that regard. So those are tough questions. They are based more on political choices that the relevant sovereign nations have to make in. But the bigger issue is, have we been successful with the existing scenario? My answer is a crystal clear no. The mutual legal assistance regime has been a regime of convenience, has not been a regime of effectiveness or efficacy. Consequently, to give you the Indian example, the Indian premier investigative agency on cybercrime, the Central Bureau of Investigation, they did a survey, and they found out that on an average, it takes them 3 years and 4 months to get information under the MLAT, or Mutual Legal Assistance Treaty, from another nation in one matter. So if the premier agency is going to get 3 years, 4 months to get the information, and the second output is that they're not able to get information in a number of cases, because that is again dependent upon the relevant reciprocal goodwill that's available in the relevant jurisdictions. So the Mutual Legal Assistance Treaty as an experiment is a broken one from the word go. It hasn't delivered. But the question is, does that mean just because it's not been delivered, it should be thrown out of the window? Definitely not. It has got its own efficacy, must be retained. However, more better, efficacious models of internet jurisdiction, I believe, need to be specifically now looked at. And I think initiatives like what Bertrand is doing would be definitely very helpful in proceeding forward in the right direction, except now the new paradigms will have to be added to the internet jurisdiction debate. The new paradigms being cybersecurity and mobile. Well, all our internet jurisdiction debates have been focused on a line-specific internet, on a computers and a laptop-based internet. However, given the huge mobile commerce markets that India and China currently are, it's very important that the mobile access has to be factored in as we go forward in determining how the internet jurisdiction has to evolve. So let me give an example. I have a mobile connection on my mobile. I take this iPad. I'm traveling from here to Geneva. And I'm in Geneva. I'm having a local connection. And I access something from my mobile pad. And lo and behold, I do something which is maybe contrary to a law in a country. So the question is, which is the jurisdiction? Is my physical location in Geneva the jurisdiction? Is my access of the local Geneva service provider the jurisdiction? Is my access to the Indian service provider the jurisdiction? Or is my ultimate place of residence the jurisdiction? Those are questions that we don't have definitive answers yet. Territoriality, yes, has given us some answers, though not the most effective and the most comprehensive in today's scenario. Indian courts, meanwhile, have gone further ahead. They've actually developed on the Zippo principle, which got developed in the United States of America, and say, well, India has also seen its growth of maturity. We've gone through the maturity curve. So we began in early 2000s when we were able to convince the courts in India that just because internet was physically located, you could access the internet in your jurisdiction, you could have jurisdiction. And for numerous years, we were able to actually convince the courts to go ahead and exercise jurisdiction only on the ground that internet was accessible through internet service providers located within the territorial jurisdiction of that relevant court of law. But over a period of time, when the Zippo principle started getting more attention in the US, the Indian jurisprudence also took appropriate note in that regard. And then finally, over various cases, we finally came across with the Banyan Tree case. The Banyan Tree judgment of the Delhi High Court has now become the de facto, shall I say, pronouncement on internet jurisdiction in the country. Here, Justice Muralidhar of the Delhi High Court went ahead and exhaustively examined all applicable laws in all parts of the world, including the Zippo test, and finally said that in the absence of any further efficacious remedies going forward, we will have to still rely upon the Zippo test. So the effects test is, by and large, the foundational principle on which the Banyan Tree judgment is based. Well, this is despite the fact that under the Code of Civil Procedure, we have various sections which provide for territorial jurisdiction of a particular court of law as well. So India is also in flux. We today do not even exactly know how we are going to actually invoke internet jurisdiction on a mobile web. So how about a guy traveling from Delhi onto a village in Hyderabad or in one of the Andhra Pradesh, and then on transit from one service provider to the other, he commits a violation or contravention. Now, given the fact that number portability has now come in, the entire canvas starts becoming far more complex rather than simple per se. So I think all these factors will have to be factored in. We are still at early days as far as landscape is concerned. I can definitely tell you the landscape is going to dramatically change in the next 2 to 3 years, depending on the developments that are taking place. But nonetheless, cybercrime and cyber security, as also the mobile web, will be very important factors now to determine the color of the canvas of the debate of internet jurisdiction as we proceed forward. Thank you.
Well, thank you very much, Pavan. And I have to say that sounds very scary, whatever it is. But we have a way forward now to try and harmonize procedures, rules of procedure. So typically what we do is to have a law and then set the rules of procedure. However, we are doing this in the reverse for cyber, it seems, which may be, in fact, the way to go forward, since at the present point in time, the subject of jurisdiction, the countries and courts are themselves grappling with what it means when applied to this particular medium. May I throw the floor open? Are there any questions that you might want to ask? And please identify yourself and keep the question brief. Yes, please.
My question is to my name is Vinay Kesri. Vinay Kesri. So my question is, and it's possible that you haven't reached this stage yet where you really had to grapple with this issue. But the thought in my mind is, how would this kind of framework be operationalized? Now, when we look at MLATs or double tax avoidance agreements or anything of that sort, it's an agreement between countries. It's either a bilateral agreement, it's a network of bilateral agreements, or it's one treaty that a number of countries or almost all countries in the world sign up to and ratify. So in this case, considering that the counterparty in most cases is a private corporation, what do you think is the ideal way to operationalize this framework? Do you think it should just be a set of principles that people agree in good faith to adhere to, or do you see it becoming some sort of more binding instrument, perhaps one where a government steps in on behalf of corporations to say that, look, all the corporations that are based in our jurisdiction will agree to these principles? How do you see that working out? Because I don't see too much precedent for it. So it's an interesting question.
Yeah, thanks for the question, which is indeed very pertinent. It's the way we qualify the framework that is being developed. And once again, I'm very careful not to say the framework we develop, because it's actually the process that is emerging and producing this framework. We often qualify it as a policy standard. So it tries to take the best of both worlds. Standards are things that are usually adopted on a voluntary basis. So the voluntary basis dimension of this framework is that the process is intended to provide incentives for each actor to see a benefit in participating in this regime. A very concrete benefit for governments is that, contrary to the current situation, where in many cases they can send a request and sometimes they get no answer at all, the deal in a certain way is if the requests are more comprehensive and more structured and contain more elements and information, then there will be a response and a procedure to handle this response. For platforms, the incentive is that within this framework, there is more predictability and therefore a little bit more protection, because they are following guidelines that have been mutually accepted. For civil society groups and users, there are procedural guarantees. But it remains a voluntary framework. And so the objective is that by 2016, there's a critical mass of actors that actually agrees to implement this framework, and that it will percolate and scale up. Today, not all countries are participating in this. Not all platforms are participating in this. And we believe that it will actually grow like the internet has grown, like the World Wide Web has grown. A certain number of actors using it, and progressively, virally almost adopted. That being said, in the medium term, or even the long term, we do not exclude that progressively the different traditional framework will embed that it will be recognized by some national laws, it will be recognized by the terms of service of the platforms themselves, and so on. But fundamentally, think of it as a policy standard, and the way it is being developed indeed is a little bit original, because it starts with the facilitators trying to develop a regime, and once again focusing on the specific cases where there is a discrepancy between the laws. Not so much the cases where cyber security and dual incrimination can be achieved, but all the cases where the differences of legislation are the fundamental starting point. So the answer is policy standard and voluntary adoption, and the hope that the alignment of incentives is actually making this more and more adopted.
May I ask a attached question?
Yeah.
Which is that the due process, which will harmonize the manner in which queries are posed to the opposite party. So you might have a country or a state instrument seeking these queries, as we had the example of CBI, or a corporation which is incorporated here in India seeking, or an individual such as myself. Would this not, or would it require require the support or the consent of the government in terms of maybe simply a notification to say, okay, these are the procedures, and anybody wishing to ask any of these questions or seeking information may follow this?
Well,
And to whom would these questions be posed? Because the state might know where to contact, who to the point of contact, or a corporation, but an individual may be floundering.
This is, you raise a very interesting dimension, which is the architecture is easier indeed to implement with very identified public legal entities. It can be law enforcement, it can be administrations that are dedicated to a particular topic. The point you raise is a very interesting one that requires probably a little bit of flexibility, which is a certain number of those requests are actually put forward by either associations or individuals after a court decision, for instance. So you go to a court, you obtain a court decision, but then it's your lawyer that actually wants to interact with the platform and say, I got a judgment in India or elsewhere, and I want you to take down this content. The problem is that in the current international environment, unless it is also considered illegal in the US or elsewhere, there's no enforceability. And so therefore, what we see as a potential evolution is that the countries themselves will see the benefit of using this procedure for their own requests, and they will progressively encourage actors to use this channel to forward their requests. And in exchange, the companies themselves will progressively say, we actually will handle those requests coming through this channel and not the ones that come haphazardly in no format or whatever. But I agree, there are cases where it's more structured and some cases where it's less structured and it has to be more flexible. It's an important distinction.
Please.
I'm Lieutenant General Ashok Agarwal. I work for an American company known as Location Labs, California-based, and we are dealing with location-based services, basically for safety of women and children, etc., etc. Right, my question is addressed to Mr. Duggal, primarily because who addressed a very important question about the web, mobile web, because now the whole thing, initially the cyber crimes were related to this because you could, with the IP address, one could locate the location of the crime. And now with the mobile subscriber roaming all over the country and also in the international scene, the things become difficult. But here I have a sort of point that wherever a person may be roaming within the country or outside, always a traceability exists with the technology. The traceability of a person, whosoever may be that operator who is supporting that, whether it's a number portability or any time, that number, wherever it was, traceability exists. Also, location also exists. So why should there be an issue about deciding the legality of the place of crime, whether a crime was being committed by a customer, either in India or abroad? So I think that's one question which I have. The second question which I have for Mr. Duggal again is to think, I mean, see this crime, the cyber crimes, like we have an organization, international organization, like an Interpol. Is there any framework today exists for the cyber crime like an Interpol police, international policing? So I think that's why my question, or there are some thoughts are being done by the United Nations or the countries to establish such organization, because just now Mr. Duggal mentioned that $1 billion being stolen by 100 banks and things, I mean, something has to be done. Somebody has to do it. We don't know even where the things are there, how things happen, the two. The last question I have, I'm sorry, this is for Bertrand. I mean, I am attending this program for the first time, but I want to understand that I think it's a good work being done to think about it and bringing a platform where there is this sort of system is being developed to generate the request and then process them and all sort of things. So I was wanting to understand, from my understanding, what is the legality of this? Are your organization, firstly a little bit about your organization, and are you making the members of the countries and the nations as member of this organization, and who is funding this organization? Does it work it under umbrella of United Nations or whatever? So I think, thank you.
I'll go first. First question, yes, it's you're bang on target. It's possible to locate the exact location of the mobile. Now, that's provided everything goes fine. There are people who use mobile numbers for the purposes of fudging or distorting their IMEI numbers. Today, that becomes a bigger challenge. But a far more complicated challenge is now put forward by these new OTTs, or over-the-top applications.
Okay.
Now, for example, all of us, or large number of people here, would be using a large number of mobile applications on their smartphones, including like WhatsApp and Truecaller. Now, problem is a majority of these mobile applications are not application service providers, are not physically located within your territorial boundary.
True.
To give an example, last week there was a huge cry in Hyderabad because 2 separate instances of gang rapes recorded on mobile scenario that large number of US entities would take is, I'm a US entity governed by US law, amenable to US jurisdiction, get me a US court order, and I will comply. So that approach, I believe, is not the correct approach because that's been rejected in China, it's been rejected in France. I see no reason why it should not be rejected elsewhere in the world, including in countries like India. But however, there's a huge time gap from the time you detect a cybercrime on a mobile or the over-the-top application, and from the time you're able to get the information. A large number of times you're not able to get information, thereby the entire offenders really are going scot-free. So there are huge peculiar problems being brought forward by these over-the-top applications. Regarding your second question, yes, we don't have an international organization yet. Interpol has got a very limited mandate, and it's basically an international police organization.
Yes.
It's now begun to start getting more sensitized towards cyber, and it's begun to start working. But still, of the kind of the organization that you are talking about, things like that don't exist. Though I distinctly believe that you require now an international police force who's only going to work on the digital. Because today, even traditional crimes have been invaded by the digital evidence. Today, even take a normal standard 10 crimes, normal actual world crimes in India, and you'll find out of 10, 6 or 7 have a digital component in terms of a use of a mobile phone, or footprints, or electronic trails. So we would require an international organization, but I think not much work has begun in this. Hopefully the Interpol can take a lead. And then, of course, hopefully that people like Bertrand can really contribute in this remarkable initiative. Congratulations, and over to you, Bertrand.
Thank you. Actually, it's an interesting segue because, as I mentioned, we did organize a workshop for the project itself at the new Interpol offices in Singapore. They have now a center for cyber innovation, I think. They're beautiful offices, actually. They're ramping up the space. But Pavan is absolutely right. There are incredible, I wouldn't say mandate and administrative limitations. As part of the discussions we're developing, we have interactions also with the UNODC in Vienna, which is the UN department that deals with organized crime. And all these international organizations share, sometimes privately, but also sometimes more publicly, the difficulty they have in terms of their own procedures to facilitate cooperation. So I agree that at the moment, even those organizations are struggling on how to organize cross-border cooperation. You asked a very interesting question, and if you're interested in the way the initiative is organized, as Dr. Govind has mentioned, my personal trajectory and career is that I've been in the French Foreign Affairs Ministry for several years, and I used to be, between 2006 and 2010, the French thematic ambassador for internet governance issues. Then I went to the ICANN board, and when I launched this project in 2012, it was with the conviction that there is a space for neutral facilitators who are recognized somehow in the community, like they have some element of credibility and credentials, but that fundamentally the legitimacy of the exercise, like any voluntary exercise, is whether people are coming or not. So we are convening processes, and so far, knock on wood, people are willing to participate, so more than 70, 80 entities that go from international organizations like Council of Europe, OECD, and other ones. It's major platforms like Facebook, Google, Yahoo, Microsoft, Twitter, civil society groups like CIS India, FGV in Brazil, Electronic Frontier Foundation, Privacy International, Access, etc. And among the governments, participants from a few European countries, including Sweden, France, Germany, UK, and Netherlands, but also the United States, India, Brazil. And so all those actors around the table are basically what gives an element of credibility. Regarding the funding, you can see at the end of the brochure, the funding is something that we try to make as balanced as possible among the different groups, because it's a guarantee of neutrality. So the fundamental actors at the beginning have been DNS operators, i.e. registry operators like PIR, the manager of .org, CCTLD operators in France, in Australia, in Canada, and Brazil. And we hope, wink, wink, that NIXI is going to join this great crowd. Among the companies, the funding has been provided by Facebook, Google, Verizon at a time, and Disney. I insist on the fact that we do not deal fundamentally with copyright issues, because this is its own space. So Disney is not there because of copyright issue, which is something that people have sometimes wondered about. They're mostly there because they have spaces and social spaces, including for kids. And the very important element is that in the coming years, and we have already started, we want to have the 4 pillars where there's also foundations and governments. And we're very happy to tell that as at the end of last year, in addition to Switzerland, who was providing a little amount of funding, the German government has been very proactively supporting the initiative and putting some money in the support. And the foundation called Sigrid Rousing Trust in the UK has also contributed. That being said, as you will see in the numbers in this page, we are a policy startup. And policy startups are very thrifty, and they start with basically love money and business angels at first, but we are right at the moment where we need to make the round A financing, as you know the expression. So make a jump from the limited amount of resources that we've had to a larger amount of resources, and we hope it will work. But I cannot resist the temptation to piggyback on one of your previous questions, because on the content aspect, the request for takedown, for instance, of content on large platforms raised the question of how do you exercise sovereignty in the digital space. And Pavan has very rightly highlighted the 2 elements of, you get data localization, for instance, and extraterritorial extension of sovereignty. But those 2 things do not scale up nicely. If everybody wants data localization, excuse me, at one point, not only does it harm the business in India, which wants to be global, but it leads to very strange situations where the data about Maltese people need to be on data centers in Malta. And when I send from France an email to somebody, one in India, one in Australia, one in Brazil, and one in Germany, then Gmail needs to cut my email address so that the data that I have sent something is stored in France. And then there's a bit in Brazil that says somebody from somewhere has sent an email. This is technically not scalable. So there needs to be something different. And interestingly, the law in Brazil that intended at first to think and implement data localization has slightly shifted in the Marco Civil in order to introduce the notion that if it is data about Brazilians, irrespective of where it's located, it needs to be accessible under certain conditions. Interestingly enough, for the lawyers in the room, there is a fascinating case currently under discussion in the US where Microsoft is being required by the US law enforcement to provide data about an account on a mail account that is stored in Ireland on the basis of a warrant emitted in the US. And this is going to go to the Supreme Court, and it's an amazing case. But the point is, those approaches are not scalable. Likewise, the initial approach of US platforms, which said we're based in the US, therefore the US law applies worldwide, has progressively been recognized as not implementable on a sustainable basis. The question you raise about location is fascinating because today the platforms basically adopt two modes of partial filtering of the content. It's either geo-IP location or what they call local lenses using the CCTLD, so google.fr, Google. Both of those solutions have sometimes unintended consequences, and they have pros and cons. And one of the things we're doing with the registries, the regional internet registries and the CCTLD community in ICANN, is to ask them to document the pros and cons of the two approaches. But you put your finger on a very important factor, which is geolocation is now embedded in most of those mobile phones. And the more you go in that direction, the more the question will be, is this going to be a criteria for access or not access? And if yes, where is the filtering being done? Is it on the mobile itself, or is it in the platforms themselves? And in that case, do they have access to the geolocation? So all those issues are going to be extremely important because there are technical implementation aspects related to the choice of options. And it is very important in those cases to understand all the consequences of the apparently equal technical solution, but they have huge consequences. So, sorry, I've been a little bit long.
Last thing you are not, is there, what is the equation with the United Nations?
Oh, yeah, sorry. So, as a former ambassador, I've participated in a lot of international discussions in the United Nations, in the CSTD, in the ITU, and so on. Just like the internet is victim of its own success, that it has brought something that is so widespread that now it brings people who are so different that there are additional tensions and there's no security and so on, it's a little bit the same with the United Nations. The key challenge with the United Nations is that because it's universal, any discussion you want to start requires the agreement of everyone. And this is exactly the problem that UNODC is encountering. It's the problem of the UN General Assembly when it wants to adopt a resolution and so on. So we see the United Nations, and particularly a certain number of its subsidiary elements. It can be ECOSOC, it can be the Council Committee on Human Rights, etc. There are sounding boards. There are places where initiatives like this one are brought so that everybody is aware of it. We work very closely with UNESCO, for instance, which has a significant number of activities in that space. But the development of those regimes need to gather the different actors, first of all because of resources, but also gather actors who agree on the notion of due process and transnational due process. And I know I'm on record here, but it's a fact of the international space that not all countries are absolutely committed in the same way to the principle of due process. And as I was explaining earlier, this is one of the reasons why we have, from the onset, engaged with Brazil and India as two major countries that do have an endorsement of this notion. There's a legal system, there's a lot of procedures, and therefore it is possible to bring a general regime. We hope that it will be adopted more and more and will resonate within the UN system. But it is a multi-stakeholder effort, and the UN is not a multi-stakeholder environment, so it makes it difficult to engage the private sector and civil society. But it is definitely something where the articulation is important, and the articulation with UNESCO and with other committees of the UN on this topic is active. And one element that I should mention, of course, is that attached to the UN is the Internet Governance Forum, which is not entirely a UN thing, but an effort has provided a multi-stakeholder space. And every year, as part of the outreach effort, we are organizing workshops at the IGF to explain and to raise awareness about the project. But this is a delicate issue, and I hope managing
Yes.
it in a balanced manner.
Absolutely, because United Nations today cannot completely isolate or leave this issue of, because internet is a reality globally.
Sure.
So I think it's a very major issue which United Nations has to address. And I hope there is no parallel effort like you are doing being done by them, because that may not really turn out to be productive. Thank you.
Thank you, gentlemen.
Yeah, my questions to,
Bertrand.
my question, but, like your time frame, this framework is under development. When it is the timeline, when is the timeline for this to get matured so that it starts, working for that? Or is there any more challenges? And then even after the framework is developed, how much time it is there any timeline we have worked out with the various countries? How will be the processing these kind of issues? And third, as you said, the US is still not going to be, because their local laws are not going to adhere to the Indian content takedown on those kind of things. Even if you submit this kind of format to them, they are not going to adhere to that thing. So how are we going to tackle this kind of issues and challenges? And the second is, of course, the comment that the legal aspects we are looking into for this jurisdictional aspect. Is there any internet architecture, the technology aspects where we can work out the privacy in the protocols or in the other IETF standards, which can automatically take the issues of these global jurisprudence and those kind of issues?
On the first question, I would say three things. And I think Pavan has sort of alluded to that earlier. At the moment, there is a race. And the race is very simple. Because there is no international framework that is emerging naturally, every single country and every single actor is left to its own device. You cannot leave those issues not addressed. And so each government, and that goes for France, that goes for many European countries, India and others, naturally is saying, if nothing is available, we need to adopt the national framework. And as I said earlier, the challenge is that sometimes they will not be compatible and it raises more problem than it solves. So there is a race. Those of us who are trying to find mechanisms for cooperation need to demonstrate that those mechanisms not only can be developed, but that they can work. And so there is a question of speed. Otherwise, additional and individual decisions will be taken that will have an intended consequence of potentially harming the infrastructure and so on. So that's point one. The second element is that a key element, needless to say, is in order to win this race, the question of human and financial resources is not a minor one. So the support that this initiative and others is getting is, I hope, this year going to catalyze support by a certain number of actors, other governments and other foundations, to make it go as quickly as possible. And the goal is, as I said, fingers crossed, to have something that can be tested at the early stage in 2016. But the third element is the race is not only to produce something and to produce something that works, but also to make it scale and to have a larger number of actors who actually join and endorse. And so at the same time, and it's always the key challenge, it's a little bit like the European Union. How do you do deepening and broadening at the same time? We need to deepen and to go to the operational this year. But at the same time, we need to reach out to other countries and other actors who have not participated so far, because otherwise you will get the same effect of, we have not participated in the development of this thing, so why should we adopt it? So that's part of the challenge. On the second question, which is the technology, I actually make the connection with what I was just saying before. The IRRs are distributing addresses, IP addresses. The way they distribute IP addresses, whether it's on a national basis or on a national basis, is directly connected on whether you can do geo-IP filtering or not. the question of geolocation is an interesting angle. So there are connections between the technology layer. In a certain way, the DNS layer and the CCTLDs, I've sometimes joked that on a legal basis, the DNS is actually a map of the legal geography of cyberspace. If you are under .cn or if you're under .fr, there are consequences. If you are on Facebook.com or if you are on Google.fr or on Google.com, there is an interplay between what I would call, a bit provocatively, the jurisdiction of Facebook or the jurisdiction of Google, because their terms of service is actually establishing rules for their own space, but whether you access it through the entry door of the local lens or another one has consequences. So it's part of the discussion to see how the technical dimension actually is providing solutions, making it harder, or is compatible with the outcome. And this is why we keep talking to the RIRs, to the DNS operators, and so on.
Any more questions? Yes? The lady. Yes, please.
Good evening, everyone. My name is Mingma, and I'm a research student in JNU, Jawaharlal Nehru University. So having heard about internet, territory, jurisdiction, it makes me feel that all the discussions have been reduced to safety, security. So relating to this, my question is, how would you balance transparency and authentication on one hand and privacy and freedom on the other hand? Because these two are like contradictory to each other. Like this question on the basis of personal level, not international or cross-border space or domain, very like individual, like how would you balance that? Because it made me think of the outrage which was generated by this introduction of Aadhaar card in India. The unique identification for Indian citizens. And there was this apprehensive of this local people or the common layman, let's say, about they were like, we should not show it to anybody or give it for as reference to everybody because the government, anybody can trace us or trace our identity. So in a very general, individual level, personal, I would rather say. Thank you.
Pavan, would you want to take a shot at that?
Well, that's a very, very tough call. We all want to make strides in that direction, though each nation is failing and is still, trying to rise up, trying to address. Let me take the Aadhaar case that you've taken. It's remarkable that the government has become the biggest collector of sensitive personal information, including your biometrics. This is despite the fact that there are questions asked on the legality of unique identification authority, which has been passed by means of an executive order. And there's no law passed by Parliament of India which actually legalizes such an exercise. On top of it, gets even more complicated because there are reports that Aadhaar does not comply completely with the parameters of the Information Technology Act 2000 and various rules and regulations made thereunder. We've had reported cases where Aadhaar number has been allocated to trees. We have cases where Aadhaar number has been reportedly given to dead people, non-existent people. So these kind of scenarios ultimately go ahead and vitiate the entire quality of the database, apart from otherwise infringing and violating on personal individual rights, to say the least. But clearly, when we go forward, these balancing act will have to be done. You can't say I'm going to be in one school of thought. Life never has black and white, it only has gray. Same is the case on the internet. Internet never has only black or white. You will have to do a constant, shall I say, harmonization of all the competing, conflicting interests in order to achieve the desired objective. How we will be able to do so, that's something that nobody has a magical answer, but surely that's the way, because that effectively addresses the concerns of all stakeholders, and yet appears to be the most logical and the rational basis for proceeding forward. Back over to you, Bertrand.
Yeah, I will consciously refrain from speaking on topics that I don't know. The internal Indian things, Pavan is much more able to weigh in. What I wanted to answer on your question is a clarification on the transparency database here. This transparency database is a statistical information on how many requests have been sent by one particular actor in one particular country to one particular recipient. You're probably familiar with the fact that major platforms have begun to develop transparency reporting. So it is growing, but at the moment it only concerns 3 or 4 key platforms. In that regard, there is a benefit in mutualizing the information, so it doesn't contain any single private information or personal data. It's only statistical information regarding how many requests have been sent for what kind of requirement. But the second thing that I wanted to highlight is you said everything is oriented towards security. And I think it's a very valid point that I would like to frame slightly differently. You may know that, like many countries, and we're not unique in that regard, there have been those events in France a couple of weeks ago. There were other types of attacks and a certain number of sensitivities regarding content due to terrorist issues and so on. What has emerged in the discussions, and I hope will get traction, is the following. Cybersecurity cooperation is fundamental. Police need to find new frameworks. Tracing back criminals and so on is necessary. But this is not and cannot be the only answer, because there is a second dimension, which is a second pillar, if you want, which is the fundamental balance between the protection of rights, including freedom of expression, privacy, and so on, and the restrictions that might be needed for public order issues and so on. Every single human rights framework in the world, including the Universal Declaration of Human Rights, the French Declaration of Rights, and I'm sure your constitution in many aspects, says there is the affirmation of rights and the conditions under which those rights can be limited for higher purposes. What unites democracies, what unites entities that are respectful of those rights, is a fundamental agreement with principles that you may call, as I said, rule of law, due process, état de droit in French, any kind of expression that is self-balanced, that contains in itself the desire to distinguish and articulate the protection of rights and the processes that are needed to limit to be implemented when you need to limit them. And I think that in a certain way, this notion of due process, to take this one, that's the one we've chosen, you can pick another one, at the transnational level is and should become the second rallying cry in reaction to all issues related to content. Cybersecurity cooperation is one. But fighting for the development of trans-border due process mechanisms, ours and others, is an essential activity that the democracies and the major operators should be fighting for. And I think India has a full place in this discussion.
I think
The last question, perhaps to...
Yeah, just
You want to ask
no, not question. I'm just answering that the Aadhaar card you mentioned, then the authenticity and the transparency and the security and all those aspects. But the issue is that, it's such a country like ours, 1.25 billion population. I think we have reached 700 million Aadhaar cards today. And there is a great effort, and, and the data are going to be with the government and public-private partnerships. And somewhere we have to begin with the authentication, somewhere we have to begin with some kind of data taking. But when we go to the Googles or the Yahoo or the Microsoft, we freely give our data and we don't question them. We blindly give everything and then we don't crib about it. But when we are giving it to Aadhaar or any government platform, we question it whether it will be kept secret or whatever it is. But that question is not never asked from the Google or any platform you use, the global companies. So, so I don't say that, you should not question or you should question, but the thing is ki Aadhaar kind of efforts, a country like India is a great effort where things have to move somewhere where identification of a person, there may be some ifs and, some issues here and there, but ultimately it has to be worked out for the country and for the betterment of the country.
Country uses the similar thing, like in US, I know, they use social security number. Everybody is allocated, every citizen or resident, not citizen. I am a green card holder. I am allocated a social security number. So there is, every details are there with the government. So it's not a big issue. It's an issue. People have to trust their own governments, the sovereignty.
One point.
Hi, I'm Jyoti Pandey from the Center for Internet and Society, and my question is to Bertrand. I know that you mentioned that you would not be, the framework that is being developed here does not seek harmonization on content. But the one issue that I'm interested in is, for example, certain kind of content that has been identified as being harmful internationally or within international frameworks. So for example, child pornography, how does the framework A deal with specific content related issues where such content is concerned? The second part of my question relates largely, so while we've discussed sovereignty and territory, I want you to briefly touch on how this framework deals with rights. So for example, human rights that should apply offline and online, and for example, free speech or privacy. And I think this is an extension of her question. How is this framework undertaking bringing certain rights that are recognized in international frameworks and by countries? And the final question that I have is giving the example of space exploration, and that would be probably one sort of framework that I have heard being discussed as a possible framework that the cyberspace should evolve towards or aim to evolve towards. Even there we see issues of rights. So for example, now with the SpaceX program, and now that exploration has taken a private scope, so how do we resolve sovereignty and private ownership of content, especially when most of the content is user-generated? So whose rights over content should matter, apart from the rights over territory and sovereignty over the content itself? Thank you.
Long question.
Yeah, I tried to answer quickly, and I think the gentleman over there may have
the very last question.
Yeah, okay. First point, you're absolutely right to point that I include the distinction between harmonization on content and interoperability of procedure to highlight that the key purpose is not harmonization on content. That being said, you're absolutely right, and there is actually a factor that drives some harmonization on substance. And surprisingly enough, it's the platforms themselves. The reason is that they want to have the terms of service. I said that basically the terms of service of platforms is the law of the digital territory that they manage. And if you're Facebook, you basically determine terms of service that apply to 1.2 billion users around the world. The interest of those platforms, for obvious reasons, is to have this terms of service as unified as possible, because you don't want to have to organize a multiplicity of regimes. So what is very interesting is that although they are use-based, they have moved in the last 5-6 years to develop terms of service that incorporate some elements that provide hooks to manage the interactions with a certain number of countries. And particularly, it's very interesting to see the evolution of provisions that say hate speech or incitation to violence and so on. These are not First Amendment approaches in the US. These are things that are trying to find a relatively common approach. So interestingly enough, those platforms are evolving in the direction of some elements that are commonly agreed. Most of them are going to continue to use those terms of service as the basis for their decisions. And so if in the course of the process there is an element of documentation of things that they seem to be agreeing upon, it will de facto not decide harmonization on substance, but recognize elements of harmonization on substance that have emerged. But it is a very different approach to say, if it emerges and if there are emerging norms that are recognized, fine, they will be documented. And to say, we gather people because we're going to develop the international framework for substance. So it's a very important distinction, but you're right, there are elements that are going to be sufficiently shared to probably represent some joint guidelines. The second element on rights, there are rights regarding what people can do and rights regarding procedures and guarantees. Regarding what people can do, the regime is fundamentally intended to establish, as we said, this balance between the freedom of expression, for instance, and the limitations in certain cases. The key element in that is using fundamental principles such as necessity, proportionality. Proportionality is a very important element, so that the restrictions to accessibility to content are as limited as possible in order to ensure respect of sovereignty, respect of what is that?
Law of conflict, proportionality, and so on
Yeah,
and so forth.
so the notion of necessity and proportionality is very important. The second notion that is extremely important and that is embedded into the regime, we call it due process by design, is the principle of notification of the user of the requests as a default. There might be exceptions, but as a principle, when a request is being made for content takedown or domain seizures, before the decision is being taken by the platform, the user should be notified, it should have the capacity to reply. So there are delays, there are procedural, but these are fundamental procedural guarantees, including appeal mechanisms and so on. So the protection of rights, again, is through the procedural aspect, because it is the best guarantee to ensure that people will experience it. The question of the parallel with space exploration, there have been a lot of discussions on whether things like the law of the sea or airspace rules could be transposed. Interestingly enough, we tend to forget that in the beginning of aviation, there was a principle that said anything that is above this territory requires authorization completely. But it went so far as there was a lawsuit, I don't remember the name, where somebody who had a field said, I own the rights above my field, and if I don't want the planes to go over, I should be allowed to say no. And then the state stepped in and said, there's no way we can grow this system if every single field owner is managing the space. So unification, and here it's a little bit the same. There are parallels to be drawn. I don't think it can be transposed one-on-one, but it's interesting to bring into the discussion people who have been involved in those things. I don't think there's a transposition directly.
And the very last question. Very last.
Since local laws are not
Speak into the mic.
My name is Rahul Sharma. I work with DSCI. Since local laws are not applicable to the servers or computer resources that are not located within the national boundaries of a particular state, so and as we have seen that MLATs are not very effective when it comes to information sharing or content takedown. So I'm thinking aloud, so I want to get opinion of the panel members on how about data centers and cloud service providers be subject to certain frameworks or policies or rules that allows them to share data directly with the companies and individuals that have asked them the data directly. This is in context with the Article 32B of the Budapest Convention, because to give an example, like if a Indian CBI wants to access some of the data, so they can directly approach Facebook in the US and get data rather than running through the MLAT channel. So I want to get the opinion of panel members on that.
Well, it's a very logical idea. The reality is the exigencies of the political powers and the exigencies of protecting the national sovereignties do not allow governments to really go in that particular direction. So that's the reason why we've not seen much kind of attraction moving forward. But now I think the situation might substantially change, with President Obama now saying that he's now going to come up with new cyber legal regime that's going to force companies to, or that's going to, shall I say, encourage companies to report cyber security breaches with the government. Things might slightly change, but yes, the bigger issue is we still don't have any international norms yet on cloud computing in terms of policy standards. There are no particular, again, international binding principles or parameters or arrangements by means of which all service providers in the cloud have agreed to a common basic minimum code of conduct. In the absence of this scenario, moving forward in this direction is going to take effort.
And with that, we come to the end of it all. I have to say that this is a way more complex sort of techno-legal domain, if you like. I mean, that word domain seems to be really very limiting than I had ever thought it would be. But I also see that this has to do with the rule of law, and it has to do with due procedure, due process. And this is very heartening. And perhaps we could take some heart from the fact that in outer space, there has been a distinct no-no to any kind of binding treaty and convention after 1979. And there are a large number of UN General Assembly resolutions, for example, pertaining to remote sensing or nuclear power sources to be used in outer space, which are just resolutions. And countries are adhering to it and following it in good faith, as the Vienna Treaty Law of Conventions requires. And there is no pressure, there is nothing binding, but they see value. As Bertrand was saying, countries, corporations, individuals, ultimately individuals, must see value in it. And I hope it all works by 2016. But certainly going ahead, I see that a large number of countries, with or without the United States participating, will adhere and link into this. And the reason why I say US is because just recently a UN General Assembly resolution in December 2014 passed a resolution to say no first placement of nuclear weapons and WMDs in Earth's orbit. Now, this is what the Outer Space Treaty says anyway. But the 4 countries that voted against it was United States, Israel, Georgia, and Ukraine. So, doesn't matter. We'll all get on anyway. Thank you very much, Dr. Govind, Bertrand, and Pavan. Thank you so much. Thank you, all of you. And a big clap.
I want to thank Paul Fenker also, who have been involved in the Internet and Jurisdiction, this project right from the beginning. And though he may be, behind the buttons, all the whatever things are coming up, but his hard work behind the whole project is commendable, and I want to thank him especially for this project.